Okay, I've now got next to my list Paul Forshee.
Good morning. I'd like to thank you for taking the time to have this hearing, especially in light of the fact that we've been getting the Jedi mind trick that it's not broken. This is in my mind great and probably fortuitous. Ma'am, you had a point earlier, and I just wanted to see if I could help a little bit with it. In the military system, when somebody comes to the chain of command with a sexual assault, there's two divergent routes for them to go. One is to let the chain of command internally handle that and deal with it. The other is for them to go to authorities such as the local PD or the state PD. Now, there is no real coordination once they go with the PD. And perhaps you all hold the keys to the Arizona Code of Military Justice. Perhaps that's something you could look at down the road for getting a coordinator, something maybe with the state police or something, and then it goes downhill from there. Because the Arizona Guard would wind up having cases that are out in Avondale, that are in Buckeye, that are in Yuma, that are in Belmont. And coordination agency-wide like that is really hard for a person who is a non-law enforcement person, merely an agency administrator, to go, hey, do you guys have that report on the alleged rape that was in Belmont? Well, the police aren't really happy to release information like that in an ongoing investigation. So the difficulty in the Guard is being able to track what is essentially a police and criminal investigation while we're merely ministerial in our actions. So there's a real disconnect there, and it's not the fault of the agency. It's a simple fault of fact that we don't have law enforcement personnel in place to coordinate with law enforcement personnel. So that's perhaps something you as the legislature could look at.
Well, and I think in the response to the report, there is a recommendation of a position being created to do that, but issues are raised about adequate funding from the legislature to the Guard.
Well,
and so that begs a whole nother set of questions that we can take up separately.
Funding may be an issue, but I think post-certification is going to be a larger issue. Because you have to be a member of a police agency to get the post-certification to become a law enforcement officer in the state of Arizona. So that's why I say maybe a liaison with a designated DPS officer who serves as the liaison for Guard sexual assault cases that are handled in the criminal community. I just wanted to hit that one. The major reason I'm here, ma'am, is because of a small piece of the report and a small piece in a newspaper that deals with Brigadier General Colangelo. Brigadier General Colangelo was fired 9 months ago using the same 20-3 that Mr. Muir brought to your attention, the notice of appointment. The newspaper pointed out, as did the investigation, that information was withheld during the course of the investigation of General Colangelo by the Air Force Inspector General, withheld by top tiers at the National Guard, and the newspaper alleges the governor's office. That information was information that was going to clear General Colangelo. The Air Force Inspector General investigation found that General Colangelo had abused his authority by firing some miscreants who had been involved with fraud to the tune of over $1.2 million, some sexual abuse, sexual assault / sexual abuse cases, and other acts that were ongoing. General Colangelo did not terminate these airmen on his own. He does not have the authority to act on his own to terminate any of these people. All of his authority is derived from the Adjutant General. The Adjutant General was briefed and in alliance with all decisions that General Colangelo was going to make, holding himself, the Adjutant General holding himself as the appeal authority for any decisions that General Colangelo would make, but initially agreeing with, saying, I'll keep an open mind, we'll hear what if they want to appeal. That never came out in the Air Force Inspector General investigation. They never disclosed to the Air Force Inspector General that all the decisions General Colangelo made were in concurrence with the Adjutant General. That was my problem when all this was breaking. Yeah, I served with Colonel White. I was the head attorney there for a few years. I retired 2 years ago. Worked with Colonel White on several of the investigations in the recruiting command. But my, I guess, ire was reached when I knew a lie had been put forth to get rid of General Colangelo. I know this because General Salazar issued General Colangelo a general officer letter of reprimand saying that he had violated the Arizona Code of Military Justice and abused his authority when he had terminated some of these people, some of these same people that he had concurred with on the termination. He gave him that letter knowing it to be false. In my mind, that's not withholding information. That's a lie. That's a lie that got a man with 34 years of military service booted within 30 days. Out on your ear. My belief and my understanding as investigations unfold now and the proper people have a hold of him, he'll be vindicated. But it's 9 months too late. He's already been smeared, and it all stems from the fact that an on-paper lie ended his military career. Now that generated traffic between the two of them, but it's all based on a lie. And at best, it's a withholding of information. That I just couldn't tolerate. That's when I came forward and talked to the newspaper, and it's ongoing. But as I say, I'm pretty sure as the rocks get kicked over, General Colangelo will be vindicated out of this. But how does that help here? Because he appealed to the governor within that 30 days, twice that I know of, via correspondence through her chief of staff, and doesn't even get the courtesy of a return letter, doesn't get a call, doesn't get a, sorry, it's done, but yet we hear about how this 30-year career can't be tarnished and a good name's going out, and the governor's fine with letting the fox run the hen house. He lied. He got this guy fired. 34 years military service. He lost his second general star because this investigation was founded. Not only lost the star, lost the job, out on his ass.
So he was up for lieutenant general?
He was up for major general.
Major general, okay.
Yeah, had been since like, I think 2010, and then this complaints were filed. But again, like I said, it wasn't just, in my mind, it's not withholding as is characterized in the report, as is characterized in the paper. It's a lie. When you put pen to paper and say, I'm giving you a reprimand for abusing your authority, knowing that you're the one that said, yeah, go ahead and do this. How in my mind you can equal that with somebody who can fix an organization from the inside, I don't know. I can't square it. That's all I have, man.
Okay, now that's helpful, and it's consistent with other correspondence I have. I have correspondence from a number of individuals who either have complaints pending and are unwilling to come forward and have different reasons for that, but generally have concern that it might affect the outcome. But also I have correspondence from individuals who have findings of retaliation or reprisal that are being investigated that will be public or will be made known public soon,
record,
that are validated by the federal entities.
For the record, for every one guy you've got like Rob White, who's still an active member and comes forward, there's scads, 60, 70, 80 per person like him that's going to come out. I know personally of people who have their maladies and will not come forward because they're still employed there. They need to get to their retirement, they need their job, and they're afraid.
And it's a tough market right now. Believe me, that's absolutely right.
Mr. Forsey, do you know if members of the National Guard or civilian members that work in the National Guard, do they have whistleblower protection?
It's hard to say, because as a National Guard member, you serve in the state with the governor being your commander-in-chief. You're not responsible to the commander-in-chief in D.C. as long as you're in the National Guard. So under the state whistleblower provisions, you would have protection. Under the federal whistleblower protections, there's a different category of members of the Guard who would absolutely have it. And those are the federal technicians who are employed on a GS scale and paid federal money, but wear the uniform to work. They don't get military pay. The AGR members and the folks who come to drill on weekends, usually you'd probably have to look at state, but there's some tie to federal. Even we serve in a Title 32 United States Code status, where the active duty soldier serves in a Title 10 status. So there's a huge difference, and a lot of the times, that's where the confusion comes in that she was talking about with the court system. You have two different military systems, but we have to, because our commander-in-chief is the governor, not the president. So state law can really have an impact.
Seth Israel?